Good morning, and thank you for joining us today for our webinar on Social Security no-match letters. Today is a bonus webinar that we scheduled due to a surprising increase in clients who are receiving these no-match letters. Judging from the over 100 people we had registered for this event, I'm assuming it's a hot topic for you as well. I'm Linda Duffy, President of Ethos Human Capital Solutions, and I'll be your moderator for today. For those of you who have not been on I'm sorry, let me try that again. If you haven't been on one of our monthly webinars before, I'll just say that we provide recruiting, training, and human resources consulting services for business owners. Many of our clients are small business owners who don't have a professional level human resources person on staff, but who need someone to talk to about HR issues when they come up. These could be how to hire, how to fire, or anything in between. A couple of quick housekeeping notes before I introduce today's expert panel. The webinar will run no more than 60 minutes in total. Please take a moment now to visit the handouts area on your dashboard. Today we have two files to download. One of them is a handout that contains copies of today's slides, and the other is an actual PowerPoint slide that has links to some important resources. You'll see that slide during the presentation, but we wanted you to be able just to click on the links that are embedded in the slide. These files will be available throughout the presentation, so again, just go to your dashboard, look for the handout section, and you should be able to download them from there. If you have questions during the presentation, please post them in the Q&A area on your dashboard anytime during the presentation, because we will be addressing as many as possible toward the end of the webinar. Just a reminder that today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today provides general information and does not constitute legal advice. The information offered during the webinar is as of today, May 23rd, 2019. As always, we recommend that you consult with your own legal counsel to address your specific situation to ensure that you have the most current information on legal matters. One of our legal experts today is Marla Merhab Robinson. If you join us for our regular monthly webinars, you know that she is a partner and head of the transactional department at Merhab, Robinson, Jackson, and Clarkson. Marla's firm is known to be responsive, reliable, and well-respected. Marla practices primarily in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law, and her firm does estate planning as well. There are many law firms in Southern California, but what sets Marla and her entire team apart from other legal firms is that she and the other members of the firm have all worked in the corporate world. This experience means that you get real-world advice and not some theoretical legal answer someone learned in school, which is what I appreciate about her and why we've been friends for a long time. Our main presenter and legal expert today is Monica Lukacek. When our clients started receiving these no-match letters, Monica was our first call. We were thrilled when she agreed to headline today's webinar because she has been practicing exclusively in the area of U.S. immigration and nationality law since 1987. She has extensive experience in advising corporate clients regarding the hiring, transfer, and retention of international employees, the immigration consequences of mergers and acquisitions, as well as complex business immigration matters. We have also consulted Monica on Form I-9 issues, and she served as a panelist on another webinar on that topic for us in 2016. You can find that on our YouTube channel if you're interested or need more information on how to accurately complete the Form I-9. So thank you both so much. Monica, I am looking forward to learning all about no-match letters and how to handle them. And with that, I'm going to turn it over to you.
Okay, thanks, Linda. Hi, Marla. Good morning to everybody who's listening in. Thank you so much for listening. So what are these so-called no-match letters, and why are we seeing a resurgence in them? The letter is actually formally called an employer correction request notice, but most of us call them no-match or mismatch letters. Basically what it is the Social Security Administration advising employers that information on their W-2s does not match what the Social Security Administration has in their systems. And we saw a lot of these prior to 2012. In fact, there was a lull and there were no match letters sent probably since 2012, so it's been about 7 years. I just want to also mention that under the law, under Title II of the Social Security Act, Social Security has to maintain accurate earnings records for all covered employees. And so that's one of the reasons why they are, they have the right to send these letters. So in March of this year, and actually last year, the administration mentioned that they were going to start following up and starting to send no-match letters. In January, it was announced, and now in March, we're starting to see these letters quite frequently. So they're being sent to businesses, third parties who submit wage and tax statements, and that have some combinations that may not match Social Security records. So what happened? What happened between 2012 and 2019? And we believe that it's probably a result of, first of all, the executive order of 2016, which stated that it's called Buy American, Hire American. And it's just kind of a continuation of change in policy, change in the way things are being done to kind of broaden the net of unauthorized or undocumented workers in the United States, to capture those. And this is one of the ways that the Trump administration has said that the government is failing to enforce the immigration law. So it's actually kind of promoted because of that executive order. The issue that a lot of us are concerned about is whether or not this number of no-match letters is going to increase I-9 audits by the Department of Homeland Security, known as DHS, or ICE. And so we want to make sure that people, employers, businesses are doing the right thing to prevent or to avoid any fines should there be an audit in the future. So again, they matter because ICE has been known to ask for copies of all no-match letters during audits. If anyone out there has been audited, you know that they ask for a list of documents, payroll records, and now they're asking for no-match letters as well. Sometimes they're used to as evidence that if you fail to respond to a no-match letter within a reasonable time, and we'll talk about that a little later on, what's reasonable, it might be viewed as constructive knowledge that a worker is unauthorized. And they can also point to the percentage of no-match letters or the number of no-match letters an employer receives to show evidence of I-9 violations. So remember, when you're encountering a possibility of an I-9 violation, the government will look at a totality of the circumstances, and now these no-match letters will be used as further evidence within that totality of the circumstances. So who else cares about not having correct Social Security information? In addition to ICE, the IRS also is concerned with having incorrect information, obviously. And in fact, there are financial penalties for not correcting W-2 statements. And there's some information here on your slide that talks about some of the different kinds of assessments or penalties that could be made by the IRS. And I don't know about you, but I certainly don't want to mess with the IRS. And so if there are any corrections that need to be made, we urge you to do that very quickly, not only with Social Security, but also with the IRS. So let's talk about the history of the no-match letter and something that's referred to as safe harbor. So historically, I have here, I stated a case that in 2006 there was a case called Ethos systems where about more than half of the IFCO employees had invalid or mismatched Social Security numbers, and they found nearly 1,200 unauthorized workers at those facilities. Well, that kind of is a pretty significant totality of the circumstances. If more than half of your employees result in having incorrect Social Security or mismatch information, that's pretty much a signal that there's something else going on, and you could probably count on seeing an I-9 audit in the near future. So after these no-match letters started to be issued, the Department of Homeland Security issued a final regulation, and it actually had more to do with I-9s than it does with Social Security. And it gave procedures, safe harbor procedures as they're called, for employers who follow up a letter to avoid a charge of constructive knowledge of hiring an unauthorized worker. In 2007, though, later that year, the U.S. District Court filed an injunction against the Department of Homeland Security, and it said they could not implement that rule, and that was done nationwide. As a result, the DHS decided to rescind that regulation, but we have to remember that we still don't have any regulations that tell us how to deal with no-match letters, what a reasonable amount of time is, how quickly we need to inform our employees. So it's always a good idea to follow those safe harbor provisions that were in that final regulation, even though the final regulation was rescinded. We have nothing else to fall back, but at least that gives us some guideline. And that's what I want to talk about next. So first of all, what does the letter look like? It's actually in 2 slides, so sorry about that. I wasn't able to get it on 1 page, but I think you can see it better. If you receive a letter that looks like this, now some of our clients have called and said, what is this? I'm not sure what this means. This is actually a template of the Social Security Administration no-match letter, so that you know. I've also been, let me just kind of digress here a little bit. I've been getting a lot of calls from clients, and I myself have been getting unwarranted phone calls saying that it's the Social Security Administration and that my Social Security number has been compromised. And so there are a lot of scammers out there. I think it's important to take a look at this template and to compare anything that you receive with this letter to make sure it is something that's authorized by the Social Security Administration. Excuse me. So the next page just kind of has information about what you should do. And we're going to get into more detail regarding what you should do and how you should do it. So this is the letter. It usually looks just like this. If you receive something else that looks a little bit shady or questionable, please reach out to your legal counsel. So, excuse me. So now you received a letter. Now what? What are you supposed to do? Number 1, please, please, please do not assume that the worker that's identified in your letter is not authorized to work. That's very important. What we have to do is we have to balance, compliance with the law on all areas, not just compliance in I-9 and Social Security Administration, IRS, but also with the immigrant employee rights section of the Department of Justice that I'll speak about in just a minute. But first I want to talk about what we need to do. So please don't assume that the employer is not authorized to work. The letter even specifically states that this does not address your employee's work authorization or immigration status. All right, and it also warns you not to take any adverse action against the employee, such as laying off, suspending, firing, or discriminating against that individual. So that's very important to remember. You want to, there's lots of reasons why there might be a mismatch. Somebody could have gotten married and changed their name. Somebody could have gotten divorced and changed their name. There could be issues of identity fraud that come up. A transposed number on the W-4 or when information is entered on payroll. So you want to check your information, your payroll and tax records to confirm that there was not a reporting or an input error on the name, on the employer side, okay, on your side. Then the next thing you have to do is inform the actual employee of this issue. And there is a template available that we will have links to later on in the slide presentation. You can take a look at that. I think it comes in Spanish as well as in English. If it's not in Spanish, it's easily translatable, very simple little template. And you want to ask your employee to confirm that his or her name or Social Security on the employer's personnel records is correct, okay? If the name is incorrect, then you want to refer your employee to the local Social Security office to attempt to resolve that no match. So yes, I got married and I never went to Social Security to change my name. Okay, well then go to the Social Security office, go have your name corrected, take your marriage certificate, get it corrected, and then report back to us. You want to give your employee reasonable time to correct that. Now, some of you know with E-Verify, it might take 120 days for certain non-confirmations to be resolved. So the safe harbor rules allow for 90 days. I would say that you could go up to 120 days to resolve the issue, even though the letter itself says to respond within 60. In my opinion, 90 to 120 days after you receive the letter is considered reasonable. If the discrepancy is resolved and the employee presents you a new Social Security card with a different name or number, you want to file a correction on the W-2 using Form W-2C. All that information is on the irs.gov website. And you want to check again with Social Security Administration to verify that all the corrections have been made. And you do that by using the SSNVS system. Again, that information will be provided towards the end of this program, but it's also on a link through the letter. The letter provides some information on that. Next, you want to record the date, the manner, and time that the corrected information was verified and retain it with the employee's I-9 form, so that if there's ever an issue with an I-9 audit, oh yeah, that Social Security was incorrect on the I-9, we had it corrected, here's the proof of it, okay? And if you need to correct an I-9, you should do so if necessary to reflect the updated Social Security information. Remember to use a different colored pen on the I-9 correction, and to date that the correction was made, add the memo that shows why the correction was being made. Okay. Sometimes it might just be a middle initial or something else that's not updated. Okay, so again, as I mentioned earlier, the Immigrant Employee Rights section of the Department of Justice. This used to be the Office of Special Counsel, and it's the department within the Department of Justice that ensures that there are no discriminatory practices in hiring or in any other areas, actually housing, all those sorts of other things that we cannot discriminate in by law. And it also wants to ensure against discrimination in the workforce, okay? So you have to balance your mandates under the Immigrant Employee Rights, IER, with your I-9 responsibilities. So you don't want to go too far. This is the situation where you over-document or you seek specific documents when completing an I-9 form. This is where we run into troubles when we do those sorts of discriminatory actions. And so per the IER, just receiving a no-match letter does not by itself, standing alone, give rise to constructive knowledge on the part of the employer that the employee is unauthorized to work. And doing so is considered unfair documentary practice or evidence of discrimination based on citizenship, national origin, or immigration status. So we have to balance that, which is why we stress, do not assume that your worker is unauthorized if you receive a no-match letter. So in order not to violate the IER mandates, remember the receipt alone is not a basis to terminate, suspend, or take other adverse action. Don't try to immediately re-verify your employee's I-9. That is not what's required here. What's required is confirming, checking your record, checking with the employee, and having the employee resolve the issue. Always follow the same procedures regardless of the class of employees. So regardless of their national origin or citizenship status. Don't do a certain type of procedure after you receive a no-match letter for employees that you know to be U.S. citizens as opposed to those that you know may not be U.S. citizens. Don't require the employee to produce a specific document to address the no-match. As long as they can show or tell you it was corrected, you can always go back and check it through Social Security. And don't ask the employee to provide a written report of Social Security verification. They may not get it. They might not have asked for it. It's just not something that you want to get involved in. You can always go back and check it after they tell you that they've corrected the matter. Excuse me. So employees have rights, and their rights are notice from their employer of the nature and source of any reported named Social Security no match. Again, because what's considered reasonable is looked at not only when responding to these no match issues, but also how reasonable is your timing to let the employee know that there is an issue. This is something that, again, there's no regulation as to how soon. However, reasonable, I would say, was as soon as you check your record, immediately let the employee know so that they have time to address it with Social Security. It does take some time for Social Security to update their records, so you want to give the employee as much time as possible. I would say probably within a week of receiving the no match is probably reasonable. Again, under the circumstances, maybe there was a holiday, maybe it's the employee's on vacation, anything like that could affect how quickly you notify an employee. The employee has a right to an opportunity to review and correct their errors on the employer records. They have a right to continued employment while addressing and resolving this error. They have a right to a reasonable period of time to gather documents and resolve the error. Somebody might have lost their marriage certificate. They need to go request a new one before they can go back to Social Security. Certain things that happen. They have a right to be treated equally as any other employees, regardless of citizenship status. And they have a right to report any violations to IER. There's an actual hotline that they can report if they feel their rights have been violated. So we need to be aware of that. Okay, so this is a question that often comes up. What if the employee quits or doesn't quit after you find out certain information? So sometimes employees quit immediately upon knowing that they had a no match situation. I think there's nothing that we can really do about that. It is just what happens. And I guess we could assume that the person either knew that they couldn't resolve the issue or was afraid to perhaps do certain things that might expose them. If they fail, they might also fail to respond when confronted about the mismatch. So our jobs as employers is to follow up with the employee, assuming they don't quit, follow up and ask them, have you done this? Have you done that? Maybe every 2 weeks would be a good time to follow up and see what the status is, and record the times the dates that you followed up with the employee and what was said. An employee at that point, when they receive a mismatch letter, they might say, well, I'm not authorized to work in the United States, or I used my brother's Social Security number, or they ask you, can you help me gain the proper work authorization? To this, as an attorney, I have to tell you your responsibility is to terminate that person's employment immediately. I get a lot of calls from employers that tell me that they have somebody working for them that they would like to help, quote unquote, help get their green cards. At that point, it's pretty much constructive knowledge that the person is not authorized to work in the United States. Not to say that they couldn't have authorization through another means, but if they're asking for assistance in gaining the work authorization, you can assume that they don't have it. An employee might also claim that after checking with Social Security, they're unable to explain the discrepancy. I would say that at that point, you also need to terminate because you do not have the proper work authorization to show that the person is authorized to work in the United States. Okay. So the next section here, this is where I was referring to a little earlier in the presentation. This site is got tons of information, very, very helpful. I recommend you to look at it even before you get a no match letter. You might want to incorporate some of the issues here. There is a way to check Social Security information on the Business Services Hotline. online, and there's a link to read instructions or video. So if you just go to this website, you can click on these different items and have information. You can retrieve name and social security errors, and you can see a video. There's instructions for employers and third-party submitter instructions in case anybody out there is a payroll company. And then the Social Security number verification service is what I mentioned earlier, that where you can check to see if information has been updated. You can also check this information earlier, like you can go back right now and check everyone's Social Security information if you wanted to on your payroll, just to see if you're going to be getting any no-match letters. And there's different ways to do it. And they also provide information on how to resolve the error. There's a sample of how to notify the employee and how to fix the errors using the W-2C. All this information is free online and can really help you kind of prevent any issues, including the receipt of a no-match letter. Okay. So I don't know if Linda or Marla have anything you want to follow up before we conclude.
I just want to clarify something, Monica. Thank you so much. Your slides are amazing, excellent, and so many of our clients have received no-match letters just in the last 60 days. So this is really timely and excellent advice. But I wanted to clarify because people always are asking me about the timing and your timing of 60 to 120 days, why it's confusing on the timing. The Social Security letter, no-match letter, will tell the employer you've got 60 days to respond to this. However, as is often the case in the law, the Department of Justice says you have a reasonable amount of time to correct it or to explain it. And that may vary depending on the circumstances. I think Monica gave the example of somebody who gets married. That could take some time, especially if they've been married and then left the country for an extended honeymoon or something. So I would recommend that you speak with an attorney. I think Monica mentioned E-Verify can put a hold on the employee, giving them 120 days. That's where we get the outside date of 120 days. So the 60 to 120 days, I just recommend that you speak with an attorney, call Monica, call us, call Linda, or HR consultant to discuss what's reasonable for your particular circumstance. And then just a reminder to everybody on the I-9s, that we all do I-9 audits. And that's highly recommended. It can often take care of some of these issues before you get the no-match letter. That's all I had.
Thank you, Marla.
You.
Monica,
I think
that was
Linda,
great.
did you have something?
Yeah, so I actually have a couple questions just to clarify a few things, and then we'll get into the questions that other people have started to post. So one of the questions, or maybe what you could do for me, is just sort of walk us through a timeline, just to sort of pull it all together. The letter comes into HR or to whomever, and sort of walk us through a little bit of timing and the steps that everybody should be taking.
Okay. So you receive your no-match letter, and what you want to do immediately, as soon as possible, I would say within a few days, is go look at your personnel records, take a look at the W-4s, any other information where you might have recorded or provided information to either the IRS, your payroll company, or to the Social Security Administration. Make sure that there was no transposed number or anything like that. You could also at that time go to the SSVNS site and double check and see who is the person who has the mismatch and what the issues might be. It might be, oh yeah, I forgot that she got married last week, and so she probably hasn't updated her records, right? So that's one situation where that could happen. But I would say you should do that within the first week. And if it's not an issue that the company made or a mistake that the company made, immediately notify your employee. Again, there's a template on that website, and I recommend you use the template and let them know in writing so that you have a record of that. You may want to call the employee in just for privacy's sake and resolve that issue with them. Give them opportunity to go to the Social Security Administration or take care of that in any way they can. I would say follow up maybe every 2 weeks. Just hey, did you get that information? What did they tell you? Were you able to go get your marriage certificate? There could be all sorts of issues. Well, we moved in the meantime. There's all sorts of things that could be happening. Um, and then, when it's about 90 days, find out again from the client, say, well, are you able to resolve it or not? And would not go beyond 120 days. That should be the end point. At that point, you probably should terminate the employee if they can't resolve that issue. And I would say one of the, I want to conclude by saying there's a couple things you can do beforehand, a couple of preventative measures. Be responsive and record your steps. Incorporate your procedures into your company's procedure manual or your process manual, or assign one specific person to handle that sort of thing. We're going to see a lot more of these, and they might come monthly. We don't know. Provide training and updates to those employees. And consider conducting an in-house I-9 audit, as Marla suggested, prior to ever receiving a visit from DHS or ICE. So just in case an event is, an audit is triggered by the receipt of no-match letters. Now, we've heard of, again, as that one company I mentioned that had that case in 2007, where more than 50% of the workforce has no matches. That is a significant amount. That requires a lot of legal counsel as to how to handle. And, of course, it has major financial implications for the company as well. So you want to be as prepared as possible, because 120 days can also fly really fast.
Well, not only can it fly really fast, but you also have a business to run, right? And so
Exactly.
talking with one of my clients,
Yes.
yeah, they had received a notice. They had received notice that 80 of their 120 employees, so 75%, had no match letters. And this was a client that we actually conducted an I-9 audit on a few years ago. And so that presents an interesting issue, because the I-9 and the Social Security numbers are in some ways linked and in some ways like not linked at all, right? So the other question I have for you is, can you talk a little bit more about that, Monica? Because sometimes we run into situations when I'm talking to a client and they're about ready to extend an offer, or I'm doing an audit, I'm asking them, tell me your onboarding procedures or something like that. They said, okay, and then I take a copy of their driver's license and their Social Security card. And I'm like, no, you shouldn't. Okay. So,
yeah.
I mean, unless those are the documents presented, right? But can you talk a little bit about that too? Because a lot of clients, I think, are mistaken about their right to require a Social Security card. And I can imagine with these no match letters, people adopting a bad practice going forward in the interest of protecting themselves against no match letters.
Exactly. So a Social Security number is not required to complete an I-9 form, first of all. That's not required. Now, it does have to be used in conjunction with identity documents to show proof of employment authorization. But proof of employment authorization can be resolved by a U.S. passport, and you don't need to ask for the Social Security number. Now, obviously, the person needs a Social Security number to do their W-4s and to get on payroll. But it's not required to complete an I-9. In fact, I represent a lot of companies that are bringing international employees from overseas. They have a plant in India, for example, and they're transferring this employee from India to the United States. Well, that person obviously does not have a Social Security number. They are not even eligible to apply for one until they get their visa and physically enter the United States. So the first thing we tell them is go apply for your Social Security number. Social Security will say, oh, it's going to take 6 weeks to get a number. They can't wait 6 weeks to get on payroll, and they can't wait 6 weeks to complete an I-9. They've only got 3 days to complete that I-9. So they use alternate documents to show work authorization, and they can also use the receipt from Social Security as an I-9 document, but a Social Security number per se is not required for an I-9. Should not be asked specific. Never ask for specific documents.
So out of curiosity, if somebody in that circumstance doesn't have a Social Security number, how does your client put them on payroll?
I believe most payroll companies, and this is something on the other end that I don't see every day, but I understand that with the receipt of the Social Security number, they can be put on payroll. And I don't know what the ins and outs of that are. I would assume the payroll companies understand how to do that. And so there's a way to do it where 6 weeks you're allowed to not have the Social Security number and still be allowed to be put on payroll.
Got it. Okay. One last question or something I just want you to speak to before, again, we'll go ahead and take questions from everybody else. I don't want to like hog up all of your time, but a lot of times when we talk about the I-9s in particular, and we know that there was this law that came out, a couple of years ago that said, if ICE shows up or Department of Homeland Security shows up on your doorstep, you have to take specific steps to notify the employees before you let people in and things like that. California is a sanctuary state. So why don't we just tell
Okay.
the federal government, nope, sorry, not going to comply, we're a sanctuary state. Can you address
Okay.
that?
Yes, absolutely. So sanctuary is a misnomer. Just because we are considered a sanctuary state doesn't mean that employers are allowed to not comply with federal law. We do have to comply with California law, which says that we need to notify employees immediately or within 72 hours. The sanctuary means is that a police department or law enforcement is not required to turn over the immigration status of detained individuals to the federal government. So what that means is if you're picked up for a DUI and you might have an immigration issue, you might be undocumented, the police department does not automatically refer that person to the federal government to investigate their immigration status. That's what sanctuary means. So a lot of people don't understand that issue. It really applies in the law enforcement arena.
Okay, great. Thank you so much for clarifying that. All right, we're going to go ahead and take some questions from anybody else. I wanted to mention another law unrelated to the topic today, but we have some people on this call that are Monmouth clients that probably have not heard this before from us anyway, haven't been on our monthly webinars that Marla and I do. There is a law that went into effect at the beginning of this year, SB 1343, that requires any company that has 5 or more employees to provide harassment prevention training to their employees before the end of the year. That is something that Ethos does. We can do it in English and Spanish. We can do it via webinar, in person, all sorts of different ways. So if that is something that your company needs, please reach out to us and you can get more information from our sexual harassment prevention training page there. So let's take a look and see what questions we have here. Okay, if I can get this to work. Hold on one second. Okay. All right, so Cindy's asking, hold on. What does an employer do if they cannot get information from the Social Security Administration, or they can't get the Social Security Administration to respond?
To respond to what? I don't know. I'm not sure. Respond to,
It does
I'm not sure
not
what question.
say. I don't know, Cindy, if you want to type something in there, maybe we can. Oh,
Well,
I'm
let me
sorry.
just
If
say
I
that,
extend, do not, it says should not, I'm sorry, it says who cannot get info from Social Security respond to the no match letter. I don't know if she means the employer or the employee. Cindy, if you want to type something in there, we can clarify that. She says the owner has tried to get more info from Social Security and has not been successful.
okay, did they go on the SSNVS site to see what information is available there? It would notify you as to who has an issue and what the issue is. So you might want to start there. Other than that, it might be very difficult for the employer to get direct information about the employee. The employee has to go in person to resolve the issue. And if you can get any federal government to respond to any questions, I'd like to know, because that's who I deal with on a daily basis, and it's not always doable.
Yeah, exactly. She also asked, and I think we addressed this, can the employee still work during the 90 to 120 days that they're checking with Social Security Administration?
Yes, they should. You should not take any adverse action.
Yeah, and I think, again, from a business perspective, I'll just think this through since I was having this conversation with my client a couple weeks ago. You have to be smart about this. If some of those employees that are on that list are, undocumented, can't provide, documentation to satisfy the I-9 requirements, what's the likelihood that they're going to stick around and wait to see if somebody comes knocking on the door? I don't think that's going to happen. And I know in the fact of my client, as soon as they're telling the employee that, hey, we have a no match letter for you, the employee is not showing up to work. So you want to be thoughtful
Yeah,
about that. And also
yeah.
sort of plan ahead, should you get some, call a temp agency, start cross-training people, like what is it you need to do to make sure your business can still run?
That's exactly what I was going to suggest, cross-training, and just know that that information is going to spread like wildfire within your company. And if so, the next day, I mean, I've had employers call me and say, I only have 5 employees, and they all didn't show up the next day. So it really, really hinder a company. Now, just because you get a no-match letter does not automatically mean that you're going to have an I-9 audit. You might want to tell the employee, this is something that we just have to deal with. It has to do only with Social Security, but we have to keep in mind that DHS will take a look at. If 75% of your employees have no matches, you could probably bet that you'll get an audit at some point. And they will not schedule the audit, I don't think, within 120 days because it just takes time. There's only one inspector in Orange and Los Angeles County who's the main person. We've actually negotiated with them several times to either reduce fines or provide additional time to make corrections. So we have a pretty good relationship with that officer. It's just something that if it crosses your mind or you want to do something preventative, give us a call. We'll be happy to talk to you about it as well.
Right. Okay, great. We have quite a few people asking your opinion on conducting some sort of background check that would show before the person's hired whether or not the Social Security number is valid or a mismatch.
Yes, and I think that that SSVNS site will do that.
Okay, so it's legal to do
How are
that.
you? But how are you going to? No, wait. Let me back up. If you haven't hired the person and you don't have their Social Security number because you haven't completed any documents for them, you can't just type in a name. That's not going to give you that information.
So
So,
let's play this out, right? So you're not subject to e-verify. You want to do some sort of voluntary. You ask, maybe it's a voluntary basis. You get someone to sign a consent. Oh yeah, you can go look to see if my Social Security number matches my name or whatever. Is that okay to do? And you would have to do it post employment, right? Because you don't have their social.
right.
And what if it comes back it's a mismatch? You
I
can't
have a
fire the
problem.
person.
Yeah, I think I have a problem. Of course, it's not anywhere in the regulations. I just think it's when you make an offer to somebody and you tell them, will you be able to show proof of employment authorization when you start working? And the person says yes, and then you complete that I-9. I don't know that you have the affirmative duty to start investigating afterwards. However, for purposes of payroll, I think if that's the purpose, not the purpose of whether or not the person is authorized to work in the United States, I would argue, okay, yes, you can do that. It's such a gray area, and there's so many competing interests there.
Right.
I would take it on a case by case basis and look at all the circumstance. Yeah.
Okay. We have quite a few questions going on here, so good thing we still have some extra time. Monica says, I received a letter. I got the passcode to verify. However, when I go in, it does not give me the individual Social Security number. How can I find out who it is since there's no name on the letter?
Hmm. Well, I suppose that would be difficult for a company that has a lot of different employees.
I've never
Yeah,
seen
you
this
have.
site. I've never tried to use it.
Yeah. So it doesn't allow you to put that person a name in. It should allow you to put a name in. Maybe if the name just comes back and there's nothing attached to it, that tells you that they don't have a Social Security number or a valid one.
Yeah, I don't know what's on the letter. I was just getting a text from another friend and client who said that she knows there's 22 employees, but she has no idea who they are.
Yeah, you
So,
have to go on that. You have to go on that site and follow the instructions from the BSO site, Business
mhm,
Systems Online,
okay,
and then see and follow the instructions there, and that'll probably, because you should have a reference number to the letter that gives you the names and what the issues are with those names. You're right.
okay.
How else are you going to notify the employee. You need to know who they are.
Yeah, Catherine says that you have to put the name in. That's what she did. And then when you go to the site, you put the employee's name in and it populates. And then once you upload, they should give it to you. So Monica, for whatever that's worth, but reach out to me after the webinar and we'll see if I can help you with that. Kelly asked, will you provide the template for the letter to employees? Yes, Kelly, that was one of the links that was on that standalone slide. So make sure you do that. Karen asked, what happens if you take action after 60 days?
What kind of action?
Well,
Like
let's
take
just,
action?
it doesn't say, but let's assume the person doesn't produce a new social security number and it's been 60 days. Can you fire that person?
You can, but I would wait until 120 just to show that you, in good faith, right, the safe harbor, good faith, you've complied. And unless it's a policy of yours that if you can't provide something within a certain number of days, then you can do it. But I wouldn't just arbitrarily, well, this person, I don't like how they're working out anyway, so I'm just going to let them go. And then another person, you would give them 120 days. I think you need to be consistent to everybody. But there is that employment in California, so.
Yeah. Yeah, I don't know. And Marla, if you want to jump in on any of these, feel free. Okay, Sean asked if we have copies of IDs and social security cards, should we destroy those documents or are they okay to have an employee file? Let me take that one, Monica. Sean, you should not have copies of those in your employee files at all. If those are the documents that are produced to satisfy the I-9 requirements, you can have a policy of copying documents, but you should have a consistent policy that you always copy documents of everybody, and you should attach those to the I-9 and keep them with your I-9 forms in a separate binder, but not in your employee file. Monica, anything you want to add to that?
Yes, and the reason I always advocate not to make copies, and you can have policy where you keep the copies and a policy where you don't keep the copies. I always advocate for not keeping them because if you made a mistake copying information, or if an auditor looks at the documents and says, well, how could they ever think that this was, a valid employment document, you're going to have an I-9 issue. And, even incorrect information on the I-9 can lead to technical violations. Those usually aren't fined unless there's a multitude of those, but it just gives the I-9 auditors more information to compare to when they review the I-9. So my advice is always don't copy them. I've heard both ways.
Yeah, so I'm going to do counterpoint on that. Coming from an HR background, it depends on how many people you're hiring. And I don't know, Monica, maybe it's okay to have a policy that says you keep them for a month or something, but here's what I know happens. You're onboarding a whole bunch of people at the same time. And it's like, if for some reason you forget to fill out the I-9 form in that moment, and now the person's out on the shop floor, or maybe they are out of state and they flew in one day, or something happens and you forgot to fill out the I-9 form, at least you have copies, and then you go, oh, okay, I looked at the documents yesterday, now I can fill it out. So I'm just a very practical person when it comes to that. Sometimes having a copy is a great backup when you just have a ton of paperwork on your desk. But maybe the practice, because I totally hear what Monica's saying. I've also done audits when I've gone into audit I-9 forms, and literally there's a picture of a man on a document with a woman's name. And I'm thinking, why in the world would you keep this as evidence? that
I've had that too.
Yeah, it's just ridiculous. I'm like, what are you doing? Like, you can't use this document. I mean, it's clearly fraudulent, but it happens.
Right. So I don't have copying, and I have a problem with keeping the copies together with the I-9 as a practice.
Okay. All right. Let's see. It says, what happens if the employee is a long-time employee? This is from Lilia, it looks like. What happens if the employee is a long-time employee that supplied paperwork previous to the law changing? Now we're getting the no match letters.
You mean the employee's been around since 1986?
Yeah, I don't know. I don't know what. Yeah, I was gonna say the law's been around a long time.
I mean, it could be. So, but yeah. So I think you still need to resolve the Social Security issue, but you could ignore it because there's really no harm in it other than it just gets unresolved. If the person is not subject to an I-9 because they were hired prior to November 6, 1986, then they're not required to have an I-9, and there might be a Social Security issue that you may or may not have to deal with. That's another case by case that you have to kind of look at the totality of the circumstances.
Great. Okay, Catherine asks, the Social Security Administration letter states that wage and tax statements, forms W-2, are for tax year 2018. Do I need to verify former employees that worked here in 2018?
Well, you can verify, but obviously you can't ask the employee to resolve it if they're no longer employed with you. It doesn't really matter.
Right, so there's no requirement to do anything if it's a former employee.
No, I mean, unless you feel like, oh, I should let this person know that there's an issue with their Social Security number, but eventually wherever they're working, that employer will probably have a no match for that employee as well. So it's not, I don't think it's for your responsibility after they're not employed with you anymore. The issue is to keep your company in compliance.
Okay, just a couple more questions and then we'll wrap this up. Stuart asked, if you have a Social Security number, can you use the site pre-hire to verify the number?
I think we talked about that already, but to verify the number for Social Security purposes, of the purposes to find out if the person can be put on your payroll, it's again, if you're trying to do kind of a workaround around E-Verify, could be an issue.
Okay. All right. Christine asks, she says she received a letter from the IRS for a non-matching Social Security number for an independent contractor, not her employee. Is there any guideline to follow, like how many days to resolve it?
Okay. So that is something that if you go to the irs.gov website, they have very specific information on what to do with the 1099 employee and how to make those corrections. And I would do that, again.
Contractor, just to be clear.
Sorry?
Not, you said 1099 employee? Just.
I mean, 1099 independent contractor. Yeah, sorry. Yeah. Thank you for clarifying that. For a 1099 person, obviously, again, it might have been a transposition in numbers when you entered the information on the 1099. You want to check that and obviously correct it if you have to. There's very specific instructions on that site as to how to make those corrections and what the penalties are. The penalties are based on the company's gross income as well as the delay in making those corrections.
Great. Monica and Marla, thank you so much for joining us today. We addressed, I think, all of the questions here, and there were more than we've seen in many, many webinars, because clearly this is a hot topic for everyone. I think that we addressed everybody's concerns, whether it was when Monica was presenting or in the Q&A section. If for some reason your concern did not get addressed, by all means, please reach out to one of us. Our contact information is on this slide. We're happy to help you. I'll also tell you, Marla and I are on our regular monthly webinar schedule, and our next one is June 20th at 11 a.m. You can register there. We do not have a topic yet, so I would love to hear from anybody if you have a topic. On any topic, whatever it would be HR related, we'd be happy to address it for you. So just shoot me an email on that. Marla, anything that you want to add?
Just a big thank you to Monica. This is just an area that is exploding and has so many traps, as everybody heard. So thank you very, very much, Monica, for joining us.
Absolutely.
My pleasure.
Monica.
Thank you.
Yeah, absolutely. I was just going to say my thanks as well. Your expertise is obvious, and if anybody has any follow-up questions, I hope that they will get with you and have you help them through this process. And with that, I will say to everybody, thank you so much for joining us today. We look forward to seeing you on the 20th. Thanks so much.